All right, we're now at 9 o'clock. Court is in session. My name is Jim Edwards. I'll be the presiding judge. With me on the panel, as you can see, are Judges Wallace and McIver. And I know everybody these days has electronic devices. If you please mute them, because they're guaranteed to go off at the absolute worst time. I can't grab them and hold them, but I was judging a moot court competition, and after giving the same speech, a very nice parent's cell phone went off during the competition. So that was happens to us all. We have two cases traveling together here at the 9 o'clock hour, cases 22-386 and 22-388. Lamb Townhouses Homeowners Association versus Hills, and Helmut Lamb, Julie Lamb, Mark Safer, etc. versus the Hills. We typically allow 5 minutes rebuttal. If you want some different amount than that, please let us know, and our marshal can adjust the clock. As you can see on our little Hollywood Square setup, there is a clock over there. If I see you getting into your rebuttal time, I'll let you know, because the light may not shine as brightly on the TV screen as it would in person. So if 5 minutes works for you, that's great. And we will go ahead and get started when you're ready.
I'm ready, Your Honor, and 5 minutes for rebuttal is perfect.
All right, please proceed.
May it please the court, my name is Patrick Howell, and I represent appellant Lamb Townhouses Homeowners Association Incorporated, which was formerly known as Lamb Townhouse Homeowners Association Corp. I have with me Robin Sievers, who wrote the briefs. She's here in my office as well. I'd like to start by going over the portions of the trial court's final judgment that the appellate HOA agrees with. The first is paragraph 5. Defendant Lamb Townhouses Homeowners Association Incorporated, formerly known as Lamb Townhouses Homeowners Association Corp., is a Florida not-for-profit corporation held out by Mr. Lamb, Ms. Lamb, Mr. Safer, and Ms. Abergele to be the association referenced in the declaration. Of note, Your Honors, the judge actually got homeowners wrong in the final judgment. It should be 2 words instead of the 1 word that was put together, but mistakes do happen. Paragraph 6. This incorporation occurred on, quote, August 9th, 2010. We agree. The court finds that the association incorporated by Mark Safer was incorporated under a different name than the one required under the declaration. We also agree with that. Paragraph 23 of the final judgment. Counsel identified a number of approaches to resolving the situation, including a name change, establishment of a new corporation, or a corporate merger. We also agreed that this occurred. Paragraph 31 of the final judgment. On August 22nd, 2018, the acting association recorded articles of amendment to electronic articles of incorporation for Lamb Townhouse Homeowners Association Corp., changing the name of the corporation to Lamb Townhouses Homeowners Association, Inc. The trial court got the name correct in paragraph 31, but not paragraph 5. We agree, and this time the court did get the name right. Those are some pretty important.
Mr. Howell, just for clarification, you're saying that was all contained within your agreement as to paragraph 31?
Yes, we agree that the association recorded the articles of amendment that changed the name. So we're in agreement that happened, and that's a fact that was laid out in the final judgment.
And that's paragraph 31. Is that what you're saying?
Yes, Your Honor, 31. Okay. Thank you. So these are some important facts for the HOA, and what it establishes, Your Honors, is that a not-for-profit corporation was established in 2010. Everybody agrees to that. It also establishes that Mr. Lamb, the developer, has taken the position that this is the HOA for Lamb Townhouses. the property in question. These facts also set that it was discovered that the name was slightly off. Also, counsel for Mr. Lamb suggested a name change as a possible remedy. The final judgment says. And then lastly, the name change was effectuated in August of 2018. So those are the facts that are established by the final judgment. As to the law, however, the HOA believes that the trial court missed the mark. Let's start with count 6, the declaratory judgment against
Mr. Howell, at this stage, the condition of the parties, has the HOA been incorporated with the proper name as it should have been when originally the sale of the townhouse took place?
Yes, Your Honor. The name is the exact name that's referenced in the definition section of the declaration. Now,
And that occurred in
That
your
occurred.
thing, 2018?
2018 was the name change to the corporation incorporated in 2010.
Okay.
All right. Your Honor, the first failing is as to the effect of the name change. The trial court held that the original name of the HOA was more than just a misnomer. However, if you look at the final judgment, there was absolutely no analysis to support the ruling that it was a misnomer. Misnomers have been recognized in Florida jurisprudence since at least 1933. That's the Stewart versus Preston case, which is a Florida Supreme Court case from 1933. What the courts have said is the general statutes of Florida provide that a misnomer of a corporation in any deed or instrument shall not vitiate the name of the corporation if the corporation shall be therein sufficiently described to ascertain the intent of the parties, and this applies to all corporations of every character and for every lawful purpose. That's the Sweet versus Ranger Realty case. Also, we cited to Fletcher on corporations. The misnomer of a corporation will not be treated as material if the identity of the corporation is reasonably clear or can be ascertained by sufficient evidence. The test in determining, and this is also from Fletcher on corporation, the test in determining the materiality of a misnomer is whether a party was or could have been misled. Here in the final judgment, the trial court made no findings whatsoever of anyone being misled or the possibility of someone even being misled. That was
Mr. Howell, is it material when you have a misnomer as far as will that affect the ability of the corporation to obtain benefits or coverage such as insurance, or will it affect the corporation and specifically the indebtedness of the corporation and whether or not it will be bound by the debts that it takes on based upon a name change, or in this situation, a misnomer of the name?
No, Your Honor, absolutely not. What the law says is that if you've got a slight difference or issue, the parties that are contracting with that entity that has the name off a little bit are still going to be bound.
But doesn't that also beg the question that you are by using that word slight difference, that is going to create an unnecessary ambiguity that would have been alleviated if there had been preciseness in the name of the corporation?
Well,
You're going to have to litigate what is slight. Is that
right.
correct?
Yes, absolutely. The trial court could have said, the word lamb townhouses is not in here at all. Instead it says Mark Saffer Townhouses, and that's completely at odds with what's in the declaration. People were misled. People could have been misled, and so this was completely an improper incorporation, and that wasn't what was held at all. There was no finding of any of that.
What case require, excuse me, counsel, what case requires that there be findings in the final judgment with regard to that specific issue?
Well, in preparing a final judgment, you're putting all of the parties on notice as to exactly what the ruling is and what the reasoning is. And so in a situation like this, where it's de novo review of a final judgment as to this issue, and as to the naming and as to whether it's a misnomer, it's incumbent upon the court to.
Did you not understand my question? I asked you what case it is that requires it.
There's no case that requires it beyond the de novo standard that applies to final judgments like this that address misnomers. So beyond that, there is no case that says a trial judge has to fully explain what the ruling is. But your honors are here in a de novo capacity to review that and look at the name and say, okay, what's the difference? Could a reasonable person have been misled by the name that was given to the corporation in 2010? The other thing is that the proof is in the pudding, your honor. No one was misled. No one came back to the association and said, we're not honoring this contract. We're not moving forward with giving you insurance because of the situation. Now, the one issue that caused everyone to say we've got to get this name right was the situation with the deeding of the common areas. So the common areas needed to be deeded in the exact name that was given in the association's declaration. And so everybody agreed that it needed to happen. It was just the mechanism that was going to move forward to perform that act. The association and the individual defendants received legal counsel that a name change was entirely appropriate. And so that's what they moved forward, and that's what they did. It was a vote, a unanimous vote of everyone in attendance at the meeting to effectuate the name change on the advice of counsel. So that had to happen first.
When you say everyone at the meeting, did that include the Hills?
It did not include the Hills. The meeting was, well, first of all, there was a board meeting to go ahead and effectuate the name change. That board meeting was posted pursuant to Chapter 720 on the property, the Lamb Townhouses property. And then the second act that happened was the actual member meeting that was held to adopt the name change. That was mailed and posted to all the parties, including the Hills. And I don't think that is contested by the Hills as we sit here today. The other thing, Your Honor, is that there was absolutely no legal requirement that the developer, Mr. Lamb, be the incorporator. There's no such requirement in the declaration. If you read it, there's no requirement in Chapter 617, the Corporation Not-for-Profit Act, or Chapter 720. And so that position by the Hills is just completely insupportable. There's nothing that
was that requirement contained within the closing documents for the purchase of the townhouse by the Hills?
So the closing documents do not make reference to the association, the declaration, or anything like that. That's not uncommon in the HOA context. In the condominium context, because the common elements are actually a part of the actual unit, you'll see that in the deed for a condominium. You'll see a reference to the declaration very often. And in fact, in the condominium context, that's why you don't have to go through the wranglings under MARTA to actually, after 30 years is up, to breathe new life into the documents. Because every time a deed with a condominium comes along, there's a reference to those governing documents. And so it breathes new life into them every single time a condominium unit is.
Also, when the association was first incorporated, it's my understanding that neither Mr. Lamb nor the Hills knew that Mr. Safer was actually filing the articles. Is that correct?
That's the position taken by the Hills, but Mr. Hill's admissions completely prove otherwise. If you look at the transcript of the trial on page 843, Mr. Hill admitted that that he met with Mr. Safer, that he met with Mr. Lamb, that he volunteered. He uses the word volunteered in Florida. I volunteered to what I believe was the association on the declaration. And then I asked what the office was. I believe they appointed me vice president.
Again, my question was, did anybody other than Safer knew that he was filing articles of incorporation?
Yes, Your Honor. That was discussed at that same meeting. The discussion was that Sunbiz had to be updated. That Sunbiz, Mr. Safer's not an attorney. He didn't use the words of art. I don't know if incorporation was used, but he said that everything has to become legal on Sunbiz. And then that's when the discussion happened about who's going to serve in what offices in the incorporated entity. So I think that it is inferred, of course, that that's going to be a corporation for the association.
But after the articles were filed, there were no organizational meetings held as would usually take place for corporations. Is that correct?
There were not. The formalities of an association were not followed. Everyone agrees to that. The Hills in their briefs, seem to indicate that that is something that's bad, that the mea culpa by all of the parties, with the association was a bad thing. It wasn't. Everyone was honest about the fact that there were no formal meetings. That changed.
I don't mean to interrupt you. You're down to about 4 minutes, which is your rebuttal time. So
yes, thank you, Judge. I appreciate it.
All right, then we'll switch over to Appellee's Counsel, and whenever you're ready, ma'am.
Good morning, and may it please the court. I'm Beverly Pohl with Nelson Mullins, and I represent Carl and Vicki Hill. It's not surprising that counsel moved directly to the issue of misnomer, but that's not the key issue here. If all we were talking about was a misnomer of the association required under the declaration, this would be a different case. What you have to focus on here is how this, I'm going to call it the acting association, just to distinguish it from the association that was actually required, how it was formed. It was formed surreptitiously without the knowledge of the developer, Helmut Lamb, and without the knowledge of the Hills. And we have set that out quite clearly in our brief, and there are factual findings to that effect in the final judgment. And one of the problems with the association's presentation on appeal is that they have ignored the proper standard of review when a non-jury trial is held and the judge makes findings of fact. Those are the facts that the trial judge found, unless they can show that they are that the trial judge's facts are not supported by substantial competent evidence. And they are in this case because Mr. Lamb testified that he did not know that Mr. Safer was filing that new corporation. And of course, Mr. Hill testified to the same thing. He thought what they were talking about at that meeting was an existing corporation. He had no idea that a new one was being formed. And they can't just point to contrary evidence in the record and say, oh, that's the real facts, because that's not the way the standard of review works here. I think it's telling if you look at the closing argument that the association's counsel made at the not just the end of the case, but it was a couple weeks after the end of the case. They presented closing argument to the trial court, and he said, quote, "Now, to be fair, it is correct that the association was not being operated in compliance with the governing documents and Chapter 720. Everybody agrees with that." And why was he correct? He was correct because there are two parts of the record that I think this court needs to look at, because I believe they were persuasive to the trial court. One is an April 1st, 2016 letter to the Hills Council signed by Mr. Lamb, Mr. Saffer, and Mr. Saffer's wife. And that letter said, "I think we can all agree that it makes sense for the Lamb Townhouse Homeowners Association to become formally compliant with the state of Florida requirements. All these units share a common goal to get up to speed with the state of Florida requirements." That means they're not up to speed now. And if they have to become compliant, then they're not compliant. That is Joint Exhibit 22 at record 6734. The second important document is Plaintiff's Exhibit 12 at record 6112. And that is the August 23 letter from attorney Brian Hess representing Mr. Saffer and Mr. Lamb. And he says quite candidly, "At this point, it is no secret that the association operated for a number of years without proper incorporation of a homeowners association pursuant to Florida law." And then he also mentions that the name is wrong. But those admissions tell you everybody knew this wasn't being done correctly. And I've already explained that Saffer did it surreptitiously. And why was that all wrong? It's because the declaration required something different. The declaration said the Homeowners Association is defined as Lamb Townhouses Homeowners Association, Inc. The only way you can get that is to form a corporation early on. And that the only person who could do that at that time was the developer, Helmut Lamb. And the common areas were to be owned by the association. And that's the incorporated association at the time of the conveyance of the first lot. First time the first lot is sold, then the common areas at that point have to be conveyed to the incorporated association. And Mr. Lamb didn't do any of that. And it's uniquely unbelievable that for decades, this group purported to have a homeowners association, but nothing was done in compliance with the law. And maybe Saffer's heart was in the right place. Maybe he was trying to fix it in 2010 when he incorporated, but really, if he knew it was, if he thought it was the right thing to do, why not just be forthcoming about it? Why not tell everybody this is what we need to do? And you know what? If Mr. Lamb had said, "You know what, Mark Saffer, I would like you to incorporate for me, be my incorporator." But he didn't do that. He didn't even know it was happening. So my overall point is here that this case shouldn't really turn on the question if misnomer, because I think that's a red herring.
Ms. Pohl?
Yes.
So my understanding is that the appellant's argument is that they were trying to convert the out of compliant association into a compliant association. And obviously they can't go back in time to the beginning of the declaration to form the corporation. What would have been their proper remedy, in your opinion, if they were to incorporate a separate association that was properly formed? Would it be your contention they would still be out of compliance?
Well,
and I understand that the Hills opposed the conversion of the acting association into a
if by conversion you mean name change, I think that would not solve the problem. And that was the Hills position throughout at the trial court level. And you know why? I will refer to the case that the appellant cited in their brief. And I have to say, I don't like to cite 100-year-old cases. But
but what I'm trying to get to is if the name change, the Hills argue, is not sufficient, what would have been sufficient in the Hills opinion?
The only thing that would have been sufficient would have been to unwind that or not, but to create for a Helmut Lamb to create either through himself or a designee, an association that complied with the name and that met all of the formalities. For example, you're supposed to come up with bylaws at the first organizational meeting. And Mr. Saffer's corporation was incorporated in 2010, and his bylaws weren't filed until 2019. That's supposed to be one of the things that's done to complete the incorporation under section chapter 617. That was never even done. Not to mention the formalities. I mean, there's such a long list of records that are supposed to be kept under chapter 720, 303, and I don't know, maybe 20% of them were available, but the Hills kept asking over and over, give me these records. And the reason they couldn't get them was because they didn't exist. This was quite honestly a couple of people playing like they had an association, but they didn't really. I want to go back to the Stewart case because they cited it, and I think it helps our case tremendously. The Stewart case says that the name change, wait, let me see if I can just find the change of the name of a corporation has no effect whatever upon its property, rights, or liabilities. It continues as before, responsible in its new name for liabilities previously contracted. That's exactly the concern that the Hills had, that because that whatever association existed in anybody's mind up until the name change, I mean, from 1988 to 2018, when the name change occurred, there was no insurance, no director's insurance, no property insurance. There were unknown risks of liabilities that the Hills did not want to assume. And they thought, and I think correctly, and the trial court agreed with them, that the way to do it is for Mr. Lamb, the developer, to create the proper association with the proper formalities and the proper documents and records and meetings and notices and insurance and all of the things, financial reports, budgets, all of the things that had not existed since the inception of this community. So it's not.
Well, was the HOA collecting HOA fees throughout this entire process?
It was, and that's contrary to the declaration, because the declaration says that the association doesn't conduct the annual assessments begin after the conveyance of the common area. And we already know, and it's undisputed, that the common area wasn't conveyed to anyone until 2018, I believe. And now we think it was conveyed to the wrong entity. I mean, yes, Mr. Saffer created an entity, but he did not create the homeowners association. For one thing, Mr. Saffer did not own the common area. How could he create an association that was there to govern the common area? It just doesn't make any sense.
Was there an accounting done or any type of accounting kept as far as the HOA fees that were collected and then how those were expended over what it was close to 20, 30 years, right?
Not to the extent that that's required by statute. I think he did hire an accountant to do certain things, but it's undisputed that the extensive types of financial records that are supposed to be maintained by a homeowners association were not maintained. No question about that.
And insurance, as far as the common areas, I believe I saw on the record that there was insurance, but actually it was the Hills insurance
Yeah.
So they got
The-
property insurance for the common area, even though they didn't have access to or title to the common areas pursuant to the HOA documents.
You know, frankly, I don't recall that particular fact, but I know that the association didn't have insurance, which if it had been the proper association, it would have been required to do. I mean, it's incredible to me that they collected assessments over the years without having the association in place. I mean, it's incredible. And there's really no case quite exactly like this, because this just doesn't happen.
Ms. Pohl, if you could just briefly, you're getting close to your time, but could you address the appellant's argument that there was a due process violation by the trial court initially dismissing count 8?
Yes,
And then I guess in the final judgment, reversed that decision.
they raised this for the first time, and that's acknowledged by the fact that they're calling it fundamental error. If they really thought that there was a due process violation, I think that would have been raised in their motion for rehearing. But if you read the transcript of what took place, they were talking about MARTA, the effect of MARTA. And when the judge made that ruling, and he was quite clear that he ruled that MARTA itself did not invalidate the second preservation. But he said, we're not done here. I'm just saying that under MARTA, there's no invalidity to the second preservation. And so it was inevitable that once he found that the acting association had no legitimacy and no right to govern the common area or the other homeowners, that everything he did was ultra vires, and the second preservation was no good because the acting association had no authority to act on behalf of that property. So there was no
So
due
is the
process
position you're
violation.
taking that the reversal on count 8 was a natural legal consequence of the other rulings that had taken place in the case, such that there was notice or there was an opportunity to be heard?
Well, I don't see it as a reversal, because the judge's preliminary ruling on count 8 only dealt with whether MARTA invalidated the second preservation. He didn't say we're done here. He never said the word I am dismissing count 8. He just said, as to MARTA, you're not going to win on that. But he left it open to see how it's going to come out at the end of the day. And yes, as a natural legal consequence of the result on count 6, count 8 had to fall. So I hope that answers your question. See, I have a few minutes left here.
If you would, please, counsel, your opponent said, in essence, there were no damages, no harm to your clients as a result of the misnomer or the failure to adopt the proper corporate form. Can you address that for us, please?
Well, we don't know what potential risks still exist by the fact that this unauthorized entity was posing as the authorized homeowners association for all those years. You know, the name doesn't change who it was. Stewart says it's the same entity. So if it was an illegitimate entity from the beginning because SAFR wasn't authorized to form it, then changing the name didn't cure it. And to give kind of a flippant example, I can call myself Beyonce, but that doesn't mean anybody's going to invite me to give a Super Bowl halftime performance, because you still are who you are. And this corporation could call itself whatever it wants. It could call itself the FBI. That doesn't give it new powers, new legitimacy. It's just the name. And are things messed up now because the property was conveyed to that entity? Absolutely, but it's not irrevocably messed up. I mean, it could all be fixed, but they have taken no steps since final judgment was entered to fix any of this. So it's it's a curable situation. It's an unfortunate situation, but this, I'll call it the Saffir entity that was incorporated in 2010 had no right under the declaration to just announce, I am going to be in charge of the common areas that I don't own. That makes no logical or legal sense. This
Ms.
trial
Paul, Ms.
judge,
Paul is, so I think what you're saying in answer to Chief Judge Edwards' question is the damages are prospective as far as going forward. What's been done in the past, that is, I mean, basically you're trying to cure the absence of the required legal documents. So moving forward, which I believe was the purpose behind the deck action, is to correct so that you do have a valid property right moving forward that the parties can convey and or operate. Is that what you're saying?
that's correct. But the Hills wanted to distance themselves from the quote acting association because of all of its failings and all of its inattention to legal formalities. They didn't want to be drawn into that. That's why I
When you
always
say distance yourself, distance themselves, that means relieve them from any financial commitment and or responsibility for how the association has committed itself retroactively or in the past. Is that what you're trying to say?
yes, that they say we're not a member because that entity was created without our knowledge with false statements on it. They put Carl Hill on there as a vice president without his knowledge. That's final judgment says that several times without
So
his
are
knowledge.
your financial damages, could those be potentially speculative damages moving forward because they're tied to the ability to convey the property rights that your clients have in the townhome community without any encumbrances upon the title?
That's one type of risk. I think there's unknown risks that could arise that we don't know about as a result of the way this community has been managed, if you can call it that. But there were actual damages that are relevant in the next case. But yes, there is unknown risk that they would like to divorce themselves from and start over. Let's have the right organization created by the right person, managed in the right way, and let's all get along and move forward. That's what they want. I see my time is up, and I want to just point to the oral pronouncements that the court made at the end of the closing argument. The trial court was very sure about this acting association and its lack of authority. And if you would look at page 1234, 1234 of the transcript, that's where the court begins his oral pronouncements, and they are crystal clear that this acting association had no legitimacy. This court should affirm.
All right, thank you. And back to appellant's counsel.
Yes, thank you. I'll address the damages first. If it's determined that there is a legitimate corporate entity and that the name change was effectuated properly, and that Mr. Lamb, who by the way appears here today, taking the position that it is a legitimate corporate entity. There was an opportunity when this was discovered that the name was incorrect, for Mr. Lamb to say, okay, Hills, I side with you. You're right. Let's do something different. Instead, through legal counsel, he said, no, this was done correctly. I agreed to it, and I'm agreeing to it now. So that's the legal position that Mr. Lamb is taking.
So, Mr. Howell, if I take your argument then to its conclusion, you're saying that proper designation or incorporation took place in 2018. Are you saying that between 1988 and 2018, there was harm, there was damage to the Hills?
No, because it was just a misnomer. In 2010, that's when the corporation was incorporated. Everyone knew that it was. Afterwards, there's correspondence discussing the corporation. It was a matter of public record. Sunbiz is something that can be easily looked up by anyone. If Mr. Hill was told and volunteered, those are his words, to serve on the board, he could have easily looked that up and seen that the name was wrong and gotten it changed. Regardless, there was no damage. The damage is if the corporate entity is determined to be, legitimate, that incorporation is what insulates everybody from any damages or from any liability. And so it's strange that the Hills are taking the position that they are, that there is no corporate entity as we sit here right now, because it does provide them with the insulation that they need. As to count 8, Your Honors, the court used the word resolved. It was done. There was actually a motion for rehearing the next day of trial by the Hills Council that was denied. And so I think it's just
what evidence were you prohibited from presenting to the trial court with regard to count number 8 by virtue of the trial court reversing on that issue?
Well, I think there would have been a full analysis as to the corporate name change, how the formalities that of the association's corporation began in 2016. So
Did
that
you
was
proffer that testimony? Did you proffer that evidence at any point?
No, because we got the positive ruling. It should have been the Hills who got the negative ruling that would have proffered. You don't proffer when you win. So the answer to that question is no. The other thing.
So we keep referring to count 8, and by giving it a name, I think we're glossing over exactly what it is. Is count 8 an answer to the question, does MARTA obviate the association required by the declaration? Or is count 8, is the association effective notwithstanding MARTA? And it seems like as we answer this question, we shift back and forth between those two answers. So which would it be?
I think the association is effective without MARTA. It was done in an abundance of caution. I think that the association did not need to actually use MARTA, but in an abundance of caution, it did so.
But what was the question that was being answered by the judge's ruling on count 8?
He just said that the mortgage is not the beginning date. And so that's how that got resolved that day. The Hills argued that you look at the mortgage to determine when the 30 years begins. And the judge says that's not the correct date at all.
All right, thank you. Your time's expired and we will be in recess.
Thank you.